is contesting the constitutionality of South Africa's Electoral Act. And it says that the act is invalid because it doesn't allow independent candidates to stand in national and provincial elections. The Western Cape High Court last year dismissed the New Nation Movement's application to have the Electoral Act declared invalid. Now, the party then approached the Constitutional Court, but it refused to hear their application for a leave to appeal on an urgent basis. The New National Movement will get another chance today to argue the merits of their case. And joining us now is Bulelani Mkhohliswa from the New Nation Movement and Professor Daryl Glaser from the Department of Political Studies at Wits University. Thanks so much for coming through.
It's a pleasure.
So let's start here. Was listening to on the news an insert there, an interview question to Pansy Tlakula about this particular matter, and she asked the question, what exactly are we seeking to change here? And that's perhaps a good place to start. Bulelani?
Well, I think it is important for us to, to clarify the fact that New Nation Movement is not a political party. It is a non-partisan movement. But coming back to your question, the matter that we're dealing with is a constitutional matter. The Constitution is very clear that every adult citizen has a right to stand for public office and have voted for hold that office. And yet the Electoral Act is limiting people to exercise that constitutional right via political parties. So that is the issue that we are raising here. And coming back to what our Spencer is raising as to what are we trying to fix here. I was saying maybe after 25 years of democracy, this is a time for South Africans to come together, whether from the academic space, from the NGO, business space, government space. Let's come together and say, what system can help us to take us further from where we are? What system can prevent the challenges that we've experienced, particularly over the last 10 years?
But what are those challenges? What exactly are we trying to fix?
Well, one of the biggest issues is the disjuncture between the people that are elected into the public offices and the distance that is between them and the voters. You'll find that the voters, are expected to vote every 5 years, and political parties make promises, and there is no, there are no mechanisms to actually hold those public officers accountable to say, the promises that you have made, you are not keeping to them. And if we're not happy about it, there's no recourse for an ordinary person. And even if, within this setup of the closed party list, we are not happy with a number of people, there's nothing we can do about it, because the system itself is limiting us only to the people that the political parties can give us.
Professor Glaser, what are your views on this particular matter and, of course, also the prospects of success for the New Nation Movement?
Well, one thing that the Constitution is very clear about is that we require a system of proportional representation. And in local government, we've got a system of proportional representation that also allows for the direct election of individual councillors. At provincial and national level, we have proportional representation, but it's based on closed party lists, so you can't elect individual councillors. So I suppose there is scope for altering the system of proportional representation to one that incorporates direct election of individual councillors and then has top-up from closed party lists or open party lists to achieve overall proportionality. So I think that's where you'd have to try and make your case, and it's important that overall, not only constitutionally, but for all sorts of reasons, important that overall proportionality is maintained. The question of whether the Electoral Act is unconstitutional, as the New Nation Movement is claiming, I think that is not very clear. I think the court could take different views. The Constitution itself is not very precise on the exact form of proportional representation that needs to be used at provincial and national level. Ultimately, the kinds of changes that the New Nation Movement is talking about would require, we're talking about constitutional changes, I think, rather than changes to the Electoral Act. My suspicion is that the Electoral Act won't be found to be unconstitutional. unconstitutional. And if the new nation want to pursue this kind of line of argument, they would have to argue for a constitutional change, which would be which I suppose the courts could require Parliament to apply its mind to bringing about.
Mr. Mkhohliswa, listening to what Professor is saying, because a part of what you are seeking is for the court to declare certain provisions of the Electoral Act invalid. And listening to what the Professor is saying, what's your take now on his view? And also, which parts are you declaring, or rather, do you believe are invalid?
Well, as I had said earlier, Section 19(3)(b) is very, very clear that, every adult citizen, it does not prescribe, that only political parties people should use that vehicle. So I think that's the issue that we're raising here. We're saying between what the Electoral Act says and the Constitution says, we're asking the Constitutional Court to give clarity, as the Professor is saying, give us direction, because when we read the Constitution, to us it sounds like every adult citizen, without the limitations and the boundaries of having to go into a political party or forming a political party. If people want to stand for their particular communities and constituencies, they do not have to form a political party. That is our understanding of the Constitution as it currently stands, which is why we've taken the matter to the Constitutional Court to say, Concord, please clarify this matter.
So Professor Glaser, on that point, is that a correct interpretation as far as you're concerned of what it says?
I think it's reasonable to ask the Constitutional Court to provide some clarification. I think the Constitutional Court is going to be wary of, if you like, triggering major constitutional changes in a situation where the law is ambiguous. We know that the Electoral Act conforms to the Constitution on the central principle of proportionality. And I think the court's going to tread warily on the question of constitutional change. But there's no reason why this shouldn't be aired. And as I said earlier, there are a variety of systems of proportional representation. And for example, the local government system, what's called the additional member system, or what in Australia and Ireland, they use something called single transferable vote. These are both methods of proportional representation that allow voters to directly choose individuals as opposed to choosing political parties while achieving proportionality. So let's have a debate about this. I think this is fundamentally a philosophical debate, a debate about the desirable form of democracy. And I think one reason why we should be having this debate, and we had a debate about this, for example, at Wits University last night, is that there is a crisis of representation in the country. One of the reasons we have such high levels of protest is because people don't feel adequately represented. Yeah.
Is it a crisis of representation, or is it a crisis of accountability, which is one of the arguments that you make? Because in the end, who elects these people? So when we argue that there's a lack of a representation or a crisis in that regard, how does that crisis even arise? Let me start with you, Professor.
Well, it's a good question. Look, I think that representation involves authorizing someone to represent you and then holding them accountable afterwards. We've got what, in effect, at provincial and national level, what's called a party mandate system of accountability. In other words, you choose the party, and then the party in turn makes sure that individual MPs stick to the manifesto they were elected on. In practice, you've got a similar system of party mandate, even in the United Kingdom, where they've got constituencies. So it's a legitimate way of doing things, but I think that because of, in particular, of high levels of corruption, I think there are lots of South African citizens who feel they don't want to have to go through the political parties to hold the individuals accountable. They want to be able to hold individuals accountable directly.
But let's look at that at the local government level, for example, where there is opportunity to directly elect a representative. What are the levels of accountability at that level? Are people held accountable? Are they removed? How is that different from what happens at provincial and national level?
It looks like, I think there have been some successes at local government level, as minute as they may have been. Even in the debate that Professor Glaser is talking about that was held at Wits last night, there was a guy who was saying, at local government level, when people are able to vote and choose their preferred candidate that they can hold accountable, it works like a charm.
How so? We see protests every single day in this country.
Well, I think that's why I was saying there are some successes, and I was just making a specific reference to what the guy was saying last night. However, even within that space, when the heads of the political party are tired of having that person, they say, even if no matter how good and how well you are servicing your constituency, move over for someone else to come and eat. So those are some of the challenges that we're having with this system. So I think the point that we're making is we're saying maybe there's a need to review the system. This opens up an opportunity for us to look at alternative approaches. We can learn from some of the best practices around the world. We can, primaries is one of the suggestions that has been made. By saying maybe let's try and look into that. Is that going to work for us here? Let's look at all the other possible alternatives, that can actually assist us. Because if anyone is going to deny the fact that this nation is in crisis, I don't know, where will they be leaving those people?
Well, I'll tell you what, of course, this will be heard later today in the Constitutional Court. So I'm hoping that we can get word from both of you maybe tomorrow after that judgment is, will it be handed down today? No?
Chances are very slim.
Very slim, not
Chances
today. But we'll see how it goes. And hopefully we'll get both of you back just to talk further about this, because as you say, it's a discussion, it's a debate that we need to have as a nation. And thank you so much to Bulelani Mkhohliswa from New Nation Movement and Professor Daryl Glaser from the Wits Department of Political Studies, talking to us about the application that will be heard in the Constitutional Court today about electoral reform. So let's keep our eyes on that one. Time now for a quick break.